Welcome, everyone, to introduce the Ambassador Tomohiro Mikanagi. Ambassador Mikanagi is the ambassador and the permanent representative of Japan to the United Nations. He also holds the title of Ambassador at Large for Cooperation on International Law and was the Japanese legal advisor from 2022 to 2024. Ambassador Mikanagi was a visiting fellow at the Center a few years ago and is currently a partner fellow. Many of you will be familiar with Ambassador Mikanagi's statement in the 2024 advisory opinion against the International Court of Justice, which focused on the prohibition on the acquisition of territorial by force, as well as his book on the subject. And indeed, it's on this topic which he will speak today, but in his personal capacity. So, Ambassador, welcome back to the Center. Or is yours?
Thank you, and thank you for very kind introduction. It is a great pleasure for me to come back to Rata Center. I was a student, graduate student about 30 years ago, and also visiting fellow at the center from 2017 to 19. As Sandy told, today's talk is in my personal capacities. Sorry about this usual disclaimer. It will give me some freedom to speak more freely in this talk. So before starting my talk, this is my personal background. I studied in Cambridge for diploma and LLM in international law, and I was visiting a fellow and then legal advisor in the Ministry of Foreign Affairs of Japan. In that period, I had opportunity to speak before ICJ on the advisory opinion on the OPT, Occupied Palestinian Territory, and that experience has let me think about this topic of acquisition territory by force. As Sandy kindly mentioned, Japan was very unique in that oral presentation. We focused solely on the issue of acquisition territory by force. Many other states talked about many different issues, but we devoted these 30 minutes per each member state to speak solely on this subject. Actually, because I imagined that this would become the main issue of the advisory opinion, and which has been left over from the previous advisory opinion in 2004 on the World Advisory Opinion. And I wrote this small book or kind of booklet after we finished our term in Security Council in 2024, because I had more time and I wanted to do something interesting apart from the work in New York. So I decided to write some paper and send to the publisher, and publisher agreed to publish this small book. I will still try to give overview of today's talk. Main part of my talk is the section 2 and 3. These are about the scope and the effect of the prohibition of acquisition of territory by force. But before getting into the main part, I'd like to put that discussion in the context, historic context. So I briefly review what we have done in the past 100 years in addressing this problem. I think I will basically focus on the prohibition of territory by force, which is abbreviated as PATF. Sorry about this abbreviation. It's not often seen in the academic literature, but to save the space in my book, I invented this abbreviation, and it worked very well. So today, please bear with me about this straight abbreviation. And at the same time, I will also look at prohibition of use of force. Is also abbreviated as PUF. PUF and PADF appear many times in my presentation. because this the UN prohibition use of force can be an alternative rule of law against prohibition to do it by force when the third states find it difficult to apply PTBL. So these two rules will appear in my presentation many times. And the third part is about the effect of the prohibition of acquisition territory by force. Two questions. First is, does the right of self-defense justify acquisition territory by force? If state is using force in self-defense, can that state acquire territory in defense of its countries? That is the first question about the effect. And second question is the obligations for the third states. This is probably familiar topics for international law students, but we look at that question in the second question section. And in conclusion part, I will briefly ask, have we made progress in the past 100 years? That is a very difficult question to answer. Now, production. This is about the history behind this question. In the interwar period, briefly speaking, Germany was not happy about the new status quo in their territory after the World War I. And the League of Nations and Kellogg-Briand Pact made effort, but couldn't stop World War II. Coming to Japan, my own country, Japan started to challenge the emerging legal regime outlawing acquisition territory by unlawful use of force. And Stevenson Doctrine, as you all know, declared by US in 1932, was a landmark initiative to stop acquisition territory by force. And it was the kind of beginning of the emergence of the PATBA in the history of international law. But I wanted to point out and reality surrounding this rule. When states, especially powerful ones, are not satisfied with territorial status quo and also unwilling to give up their interests for the sake of international peace and security, there is always inherent difficulty in the world to stop attempts to acquire territory. This is a kind of sad reality, but I think it is important to bear this fact in mind. After the World War II, as you know, UN Charter prohibited use of force, but as you know, UN Charter does not explicitly refer to the prohibition of acquisition of territory by force. And first of this concept emerged was 1967, and when Security Council adopted Resolution 242 about Middle East, and it mentioned acquisition territory by war. After that, 1970, the Friendly Relations Declaration adopted by the General Assembly clearly mentioned this prohibition. Maybe for the first time in the official document adopted by consensus in the UN. So I think interestingly, I think it is very interesting. I mentioned that inherent difficulty in stopping acquisition territory by force. First component element was dissatisfaction of the powerful state about territorial status quo. And why P5 countries agreed to this 1970 declaration, and it implicitly indicates that at that time, at least, P5 were happy about the territorial status quo in the world. That must be the reason why we could adopt this declaration. And question is, we adopt same resolution now? That is a kind of a difficult question to answer, but at least at that time, they agreed. And until 2014, when Russia attempted to annex Crimea. I think P5, a nuclear weapon state, did not attempt to acquire territory by force. There was 7 decades of success in stopping Russian territory by force by the powers. That itself is a remarkable achievement, I think, but it was kind of a temporary success, which has become right time to review the current state of international law. And also, currently there is effort going on in stopping the acquisition territory by force. I think still majority or overwhelming majority of UN member states are, I think, holding prohibition of acquisition territory by force. But Security Council doesn't work when P5 exercises veto. As an alternative to TA resolutions and ICJ advisory opinions are often used. And what is the significance of GA resolutions? That is debatable, but when resolutions are adopted by overwhelming majority, I mean like 140 in favor and less than 10 against. That, to me, or maybe many diplomats working in New York, really overwhelming majority in the General Assembly. That kind of situation, the GA resolutions have some weight as evidence of a member state's opinion. And for example, ILC quoted GA resolutions adopted in 2022 in the Youth Covenant's conclusions was drafted by the Brady, current ICJ judge, quite extent. So some GA resolutions are referred to as an evidence of a state's opinion on the existence of rule of law or interpretation of rule of law. So, also ICJ advisory opinion has a weight, especially when they are talking about UN Charter, because ICJ is the principal judicial organ of the UN. Even though advisory opinions are not binding in a technical sense, their opinion is respected. So these that have been utilized by the, for me, overwhelming majority of states in the General Assembly. And there has been criticism about the double standard especially after 2022, Ukrainian Russian invasion of Ukraine. But you can pursue single standard rather than double standard through these tools, GA resolutions and advisory review. So moving to the main part of my talk, it is about the current state of rule of law. And the scope is relevant prohibitions. I think to apply this algorithm is always a challenge. But in my view, this context and act are important. I think if you examine the acts which contribute to the attempt to acquisition territory by force and the context surrounding that act and analyze on the case-by-case basis, and you can find some conclusion on the application of use adverb. In other words, it is difficult to say kind of automatic condition or application for elements constituting the violation of PUF and PATBF. And this approach is similar to the approach taken by Erin Popugier. I think she was here several years ago. I met her here. She wrote a book titled Prohibited Force. And she used this kind of approach, combining acts and the context together and examine if the combination exceeds the threshold of the violation. And this approach is, I think, also taken explicitly or implicitly by many governments. In answering the question to the parliament, our government always say the case by case analysis is important and elements relating acts and context and others will be taken into account. So this approach is nothing new to the government legal advisor like me, but I will look at the contextual issue and then look at acts and then combine them together and discuss what kind of would violate these rules. Before looking at these elements, I would like to introduce another abbreviation. Sorry for that, but in comparing PUF, prohibition use of force, and PATBF, it is useful to note two different kinds of prohibition of use of force mentioned in the end relations declaration. First type of prohibition of use of force is the prohibition use of force to violate existing international boundaries of another state. And I call it type 1 PUF. I'm sorry about this as a abbreviation. This type of PUF applies to internationally recognized deployment of force to internationally recognized territory of another state. That's right. The second type of PUF is use of force as a means of settling international issues and use of force as a means of solving international disputes, including territorial disputes. And this is mentioned clearly in the Friendly Relations Declaration. I think it is interesting that Article 1 of Kellogg-Briand Act actually refers to similar concept. It prohibits recourse to war for the solution of international controversies. So that concept is still there in the Friendly Relations Declaration as a second category of prohibition of use of force. This may sound a bit unfamiliar to you, but please forgive me for using this concept in the following, because it's useful for the comparison of the two prohibitions. And it's becoming a bit more complicated. But in the following, I will focus on this scenario as a potential attempt to acquire territory by force. And state deploys armed forces to an area of land which is not its internationally recognized territory and put it under its control, and then take measures to annex. There might be other possible scenarios, but this basic concept captures almost all the existing examples of attempts to acquire territory by force. So in the following, I will use this model as a potential acquisition territory by force. And for this kind of situation, what is the important context to apply these prohibitions? That is the status of the area of land concern. That is the most important context. As I mentioned, in the context of type 1 EUF, internationally recognized territory is a strong element, context, and contributing to the violation of PUF and PATBF. It's not automatic, but kind of nearly automatic application that if a state B deploys armed forces to state A's internationally recognized territory, it is very likely to violate type 1 PUF. And if state B declares its station, it is also likely to violate PATBF. And this likelihood, I think, is supported by the overwhelming support to the GA resolution ES11/4 adopted in October 2022 about Ukraine's Russia's attempt to annex Ukraine's whole. The vote was 143 support, 5 against, and 35 abstention. So for me, this was a sign of strong opinion among the members. Here, I would like to draw your attention to the advisory opinion of 2024. Was it about internationally recognized territory? Actually, no. It was not about a state internationally recognized territory. It was OPT. And OPT was not treated as a state territory in the ICJ's advisory opinion. This question is becoming a difficult question, but whether prohibition use of force applies to situation not between states have been very controversial, and many authors have written about it, and many of them are negative about application of prohibition use of force to non-state situation. But ICJ did that in this advisory opinion. They applied TBF and PUF in one stroke in paragraph 179. It was very interesting, but ICJ didn't clarify any criteria for the application of PUF to the situation not between states. But it is difficult issue for me to go any further from here because there's no indication of criteria. But also, this application of PAT, PF, and PUF was interesting. ICJ was looked like applying these prohibitions to an area of land, OPT, which has potential to become another state's territory in the future. And this potential for becoming other states' territory is an interesting possibility. And it leads to a question: does the PATBF apply to an area of land with a competing claims or disputed by two or more states? This is a kind of key question to understand the difference between the two prohibitions, PATBF and PUF, to me at least. This red box, there's state A and state B have competing claims over an area of land, and B deploys armed force to the area. And this one would probably satisfy the violation criteria for the violation of type 2 PUF, which is a use of force for solving international dispute. And this is exactly the international dispute happening on the area of land. So if B uses force to solve that issue, this PUF type 2 should apply. But if B declares annexation as also PATBF apply, that is a key question as today's talk. Is relating to the relationship between these two, PATBF and PUF. Here, ICJ didn't talk a lot about this relationship. ICJ in the War Advisory Opinion and the 2024 Advisory Opinion simply said PATBF is corollary or PUF. That's all. What is corollary? That is a very ambiguous term, and no clarifications are available. And here in the blue rectangular box, there is my understanding of this difference. PATBF denies the acquisition of territorial title, not the control over the land. And if often state B has a stronger title, does not violate PATBF by sending armed force to the disputed land. In that sense, PATBF has a narrower scope of application than type 2 PUF. For example, as you might know, territorial Ethiopia case. Territorial Ethiopia Claims Commission found that Eritrea violated the PUF by sending armed forces to Padome. It was on the border between Eritrea and Ethiopia, but Ethiopia was administrating Padome before this incident happened. But Ethiopia boundary portion, on the other hand, found Padome to be Eritrea state. In such a case, I think Eritrea would not violate PATBF by deploying armed forces to its own territory. That is my understanding. And this understanding is correct. PATBA has a narrower scope of application than type 2 DUL. This is probably something new, and I'm not 100% sure about the correctness for this understanding. And this is partly why I'm here to talk to you and see if you also agree with this understanding. It's a very simple, I think, logical understanding of these difference of these two prohibitions, but it's a kind of starting point for thinking about the scope of the application. And if this understanding is correct, there is a consequence. For third states, in my view, it is difficult to know which one has stronger territorial title. So for third states, it is very difficult to apply PATBF. But type 2 PUF is probably easier to apply because it is probably clearer to acknowledge the existence of competing claims. And then one side deploys armed force, this prohibition might apply. But at the same time, does it always violate type 2 PUF is another question. No, so that is the next to think about the difference between these two. It's even more complicated than talking about that, but it is a complicated situation. So I think it is. I couldn't simplify this slide any further. But what I'm talking about is application of type 2 PUF to the territory subject to competing claims. Again, as I mentioned, Territorial Claims Commission dealt with similar situation, and Territorial Claims Commission applied type 2 PUF and found territorial violated this prohibition. And in that finding, they used the term peaceful administration existed in Badome by Ethiopia. But actually, this finding was criticized by some or many international lawyers, including maybe Christine Gray. I think this criticism have some point, I think, because what does the commission mean by peaceful? Peaceful administration, in my understanding, just meant Ethiopia was administering Badome peacefully at the time of the invasion and probably since 1993 when Eritrea became independent. The incident happened in 1998. It was only 5 years since independence. And that commission did not examine the roots of the conflict. The roots of the conflict was a mandate of the commission, but it did another commission, but it did not actually materialize. So actually, the root of the conflict was not clear. That means was this administration established peacefully, or was it established through use of force? It was not examined by the committee. So I think this is a very important issue. No, another extreme example is Nagorno-Karabakh, maybe. No, Armenia's control over Nagorno-Karabakh since 1992-94 was established by use of force. In 2020, Azerbaijan took it back, and 2023 took it back by use of force. In this case, was the Armenian control over Nagorno-Karabakh peaceful? That is probably almost the same question I'm asking to the Badome situation. But the commission actually, I think, used peaceful administration almost as the same as de facto administration and applied this prohibition on use of force. So this is still, I think, controversial. I think it is better to have more peacefulness in the administration. I came up with the peaceful establishment of administration. Here, this rectangular blue box number 2 is if A has not used force in establishing administration, state B has not protested to it. This sounds familiar to you, I think. Max Huber in the Island of Palmas case took similar concept as a basis for entitlement to the territory. So didn't use force in establishing administration and not protested by other states. That is my definition of a peaceful establishment of administration. And this type 2 PUF, in my view, is related to the obligation to settle disputes peacefully. It's under Article 2, Paragraph 3 or Article 33 of the UN Charter. And naturally, this application of this prohibition use of force have some linkage to the peacefulness of the establishment of the administration. That is the case. This peacefulness in established administration should have some more positive effect in applying the type 2 PUF. That is one possibility. But that is not enough. The rectangular number 3, B became aware of the administration by state A, but did not protest. And also this administration or this administration continued for a very long period without protest. These elements should further contribute to type 2 PUF violation. They are, I think, stronger justification for the application of type 2 PUF than peaceful administration in the sense territorial Ethiopia claims commission applied. So the last question here, if number 2 and number 3, these elements exist, does the PATBF also apply? Can third state decide to apply PATBF to this situation? And this is a very difficult question. But for me, I think there must be a case where even there are competing claims, the PATBF should apply. Because in some cases, states make claims, even though they know they have very weak, basis for the title. And if you say, PATBF never applies to the area subject to competing claims, that will create a big loophole, self-judging style of loophole. And that is not acceptable as a rule. So there must be a limit, but I don't know what is the limit. Now, so these are about the context relating to application territory by force. And next, act, and the other elements of acts. There are several acts contributing or constituting violation these two prohibitions. The first one is an obvious one, use of armed force is required for the violation of these two prohibitions. But by armed force, I mean not only regular armed force, but the security force, police force, irregular force also should be included in armed force. The second act or element of act is coercive intention. This is more controversial. And in 2002, Cameroon, Nigeria case, Nigeria argued that their action was based on the reasonable mistake or honest belief. And I think ICJ seemed to be accepting, at least partly, this plea. So several scholars have concluded that This would mean coercive intention is necessary for applying prohibition use of force, not PATB, PUF. But what is reasonable or honest depends on the situation and it's a little bit subjective concept. So it depends on the situation. For example, if state B deploys armed forces to an area where state A has peacefully established administration, like number 3 situation on the previous slide, and B has been aware of it, and B claim to be honest in sending armed forces to the area to take control. Probably not. And at least the burden of proof for state B to prove the lack of the coercive intention must be higher than other situations. So it depends on the situation, but coercive intention is probably necessary. Another next non-violent use of force is a little bit different. In Costa Rica, Nicaragua case, in judgment in 2015, I think some of you know, but Judge Robinson and Judge Wada argued that Nicaragua's deployment of armed force to the territory, disputed territory, amounted to violation of prohibition use of force, despite the absence of any damage or injury caused to the Costa Rican side. And the force was very small and carrying very weak weapons, and Costa Rica did not try to stop on the ground. So there was no exchange of fire took place, and there was no damage or injury. But Judge Robinson called it non-violent use of force. And I think he is right when non-violent use of force has some gravity and create a fait accompli by actually being present in the disputed territory and here the other side to compete with that force. That itself, depending on the situation, could be unlawful use of force. But in that sense, as Judge Robinson was correct, but it depends on circumstances. So non-violent use of force can be constituting. In the case of competing lanes in the remote island, this kind of thing may happen because remote island is not always controlled effectively by payment, so that could happen. And also gravity. This is another controversial issue in applying the use of the venom. There's a disagreement on whether gravity set the minimum threshold for the application of Article 2, Paragraph 4. I avoid to make judgment on that long-standing discussion, but I think there's an agreement among most of the scholars that gravity continued to the violation of PUF and probably PATBF. So the graver the use of force is, the greater the possibility of violation. That kind of causal link, I think, exists. In that sense, gravity matters. In addition to that, to violate PATB, there are two additional elements of acts necessary: establishment of control through coercive measures, and acts displaying intent to exercise permanent control. This last one actually came from ICJ advisory opinion in 2024, because in that case, Israel did not expressly declare that they will annex OPT, but ICJ found the violation of PATF because Israel's policy and practice amounted to acts displaying intent to exercise permanent control. Intent to exercise permanent control was the term used by ICJ. So even if no explicit declaration of annexation exists, the de facto kind of occupation can be violation PATBF if it displays this kind of intent. So these are the contributing to the violation. The last one is the most complicated slide, but this is kind of a combination I mentioned earlier of act and context. The left-hand side in the vertical order, I put three contextual elements I mentioned earlier: square 1 to 3, internationally recognized territory, peaceful administration. Here I put 20 years for the number 2 and 50 years for number 3. These 20 years and 50 years may sound arbitrary choice, but yes, this is partly arbitrary choice. But I chose 20 years as a period. It is clearly much longer than 5 years in the case of Padme. Ethiopia controlled for 5 years over Padme, but 10 years is much longer. 50 years is actually inspired by the Diktan-Spatan case in ICJ. It was a territorial dispute, but ICJ found Malaysia took administrative measures in Diktan and Spatan Islands for 50 years until the critical date. They didn't say 50 years, but you count the years. It's about 50 years. And ICJ called this 50-year period a considerable period of time and said that court cannot disregard the fact that at the time when these administrative activities were carried out, neither Indonesia nor its predecessor, the Netherlands, ever expressed its disagreement or protest. And it was the key, I think, element in ICJ's determination of sovereignty. So, 20 years, 50 years, but these are kind of examples of the strict years. And two elements on relating to acts, violent and non-violent use of force are put on the horizontal order. Then, red and blue boxes indicate the likelihood of a violation in my views. So in scenario 1, directly organized territory, as I mentioned earlier, A to E is very likely to violate both PUF, type 1 PUF, and PAT. In the latter cases, scenario 2 and scenario 3, it becomes more difficult, partly because for the third state, it is almost impossible to determine which one has stronger territorial title. But I also mentioned there must be a limit. And if you go from scenario 2 to scenario 3, the likelihood of data A to have territorial title will increase. And I think naturally the likelihood for PATBX application will increase. That is my understanding. But as I said, it is probably in the real case difficult for third state to determine this kind of thing. But if the PATBF is difficult to apply, there's always a possibility of applying PUF, especially type 2 PUF. And that rule is actually very important in the probably discussion among GA members. And there is a disagreement about the physical status of the place the armed forces deployed. I think alternatively, prohibition use of force should be looked at. So this complicated matrix explains my basic understanding of the difference between PATBF and PFF and also the consequences arising from that understanding. So I'm not 100% sure, but I did intended to give you also maybe the effect of the PATBF. First, self-defense. Can self-defense justify acquisition territory by force? I think answer is no. But why no? 1970 Federation Declaration quoted here clearly denies any application of territory by use of force without any condition. And actually, Japan, in the oral presentation, made this point and argued that it does not justify application of territory by force. And ICJ said this on the right-hand side, paragraph 253 and paragraph 254 is quoted here. Occupation can under no circumstances serve as a source of title to territory or justify the acquisition by the occupying power. And it also mentioned that Israel's security concern cannot override PATBF. It's also mentioned in paragraph 254. And it, I think, at least strongly indicates that PATBF denies aggression territory by occupation involving use of force. I hope there is a consensus about this finding. And this finding itself is very important, in my view, right? And does not only apply to OPT, but also apply to Russia. As you know, Russia justifies its invasion by referring to collective right of self-defense. President Putin's letter, which was a statement and which was sent to Security Council as a letter attached to the President of the Security Council, and also they sent the same statement to ICJ in the proceedings on genocide convention. They emphasized the collective self-defense, but when Russia attempted to annex all regions of Ukraine, they violated PATBF. Whether or not they claim there was right to self-defense. And this is probably useful single standard I mentioned, where there's no disagreement for to be applied in any place in the law, regardless of the political context. So I think this is important. Next effect is obligation for third states. This is familiar subject to international law students. Maybe you know better than I do. As in the Uniform Doctrine itself was about third states' obligation not to recognize. At paragraph 278 of Advisory Opinion of 2024 mentioned 5 obligations. And they are categorized in 3 obligations here. Number 1 is obligation not to recognize, the most obvious and famous one. And second one, obligation not to render aid or assistance. And third one was obligation to cooperate or ending violation. ILC's articles on state responsibility talks about these obligations in Article 41, paragraph 1 and 2. And paragraph 2 of Article 41 talks about first and second types of obligation. Now, Article 41, paragraph 1 refers to the third kind of obligation. But as you also know, ILC says this may reflect progressive development of international law as of 2001. As on the other hand, might be well known in 2022 on the draft conclusion on use organs drafted by the Utradi. Conclusion 19 also refers to same obligation. This commentary explains that it is now recognized under international law. And I think it is significant that ICJ recognized this third category of obligation. One thing that is not very clear is that ICJ referred to not only the violation of PATBF, but also the violation of right to self-determination. In my reading, I think both contributed to the emergence of these obligations. So it does not at least die. These obligations also come from PATBF, not just from the right of self-determination. So in the case of Russian invasion of Ukraine, many states took measures against Russia. And there are many discussions about the third-party countermeasures and so on. But in my view, I think this third category of obligation is important. And this should be taken into account in interpreting or applying the relevant rules of international law to these measures taken against Russia. The result of this taking into account is not clear, but still this obligation exists and states are taking measures partly to stop Russian aggression or Russian attempt to acquire territory by force. So if you are applying the trade rules, investment rules, this obligation should be taken into account. But this obligation, I must admit, is not so strong obligation. I mentioned in my book is similar to due diligence obligation. So states implement this obligation in their capacity and commensurate with the seriousness of violation. There is a limit, and I think it's not very strong obligation, but it's important to take into account. Last week, as a conclusion, to conclude with pessimistic view, unfortunately, still that inherent difficulty is there, or maybe emerged. As I said, 1970 was probably the high time, and now that high time is gone. So powerful states, they consider themselves as powerful enough to deter other states from invoking right to self-defense and intervene into the situation, and also consider themselves as resilient enough to survive measures taken against it. Unfortunately, international law cannot effectively prevent it from attempting to acquire territory by force. So what can we do now? This is another weak conclusion, but I think use of force, use of international law is useful. I quoted Kennan and Bryari. As you may know, Kennan for international law as gentle civilizer of states' behavior, and Bryari for the institution for saner international order. The still inspirational description of international law is not the panacea, also Bryari said, but it works if wisely used. But how wisely it should be used? As I mentioned, development of a single standard through advisory opinion or general assembly resolutions I think useful. And also, what has become clear should be utilized as a path defense or PATPF. Denial of acquisition to self-defense is very useful and universal single standard. And also, the use of type 2 PUF should be considered as an alternative rule. So these are still conclusion. Also, obligation, especially number 5, obligation is useful. And if states do not want to violate the obligation of third, they should take proportional approach. And that would have some impact on this violator of international law. And lastly, I believe in legal advisors. By legal advisors, I don't only mean the government legal advisors, but people directly or indirectly advising governments have responsibility as the stabilizer of international relations. Difficult at this time But we should make efforts to advise policy makers to make legally sound position. Easier said than done, and we are struggling every day with this heavy responsibility. But this is also the way we can contribute to the safer international work. Thank you very much.
Thank you very much for taking us through some very, very complicated issues. It's not just structured